Hello and welcome to this session, Human Rights and Climate Action, Vanuatu and the International Court of Justice. My name's David Schukman. For many years, I was a journalist and I'm your moderator for this session today. So it's very good to see so many people joining from around the world. So whichever time zone you're in, I hope you're able to stay tuned and take part. And it's great to have you all. Right now, the island nation of Vanuatu is recovering from not one horrible, devastating cyclone, but two back to back. Thankfully, from the reports I've seen, there have been no casualties, but we know there's been a lot of damage caused to many critical infrastructure facilities on the islands. And so it's a major reminder, if you like, of the imperative for so many nations around the world of seeing action on climate change, because the science could not be clearer that the risks of more severe impacts of the kind that Vanuatu has just experienced are going to be increasing. In fact, some years ago, I saw for myself on another Pacific island nation, Tuvalu, really terrifying effects of sea level rise, of saltwater intrusion through the coral rock into the soils, making agriculture extremely difficult, the effect of increased storminess and of droughts. Just a compound series of challenges exacerbated by climate change and really raising questions about the future existence of a number of nations around the world, particularly small island states in the Pacific. So Vanuatu is not sitting back and letting this happen to it. It is, as we all know, leading an initiative to try to get an advisory opinion from the International Court of Justice on climate change, which is a fascinating initiative. And the latest we hear from New York, and we're going to be getting an update on this, is that there's momentum behind this initiative. So this is a session to try to understand exactly where we are with this, the legal implications, and the potential for what this might mean. So I'm going to introduce our expert panel shortly, but first we want to hear from the Minister for Climate Change for Vanuatu, Ralph Regenvanu. Now, he's actually leading the disaster response on the islands right now, so he's unable to join us live, but I'm pleased to say that we do have a pre-recorded video from him, and so let's take stock and hear that first. So this is Minister Regenvanu.
Good morning. I'm very pleased to address you today to discuss an existential issue for the nation of Vanuatu, and indeed the entire planet: climate change. For more than 5 decades, science has been providing stark warning about the chemical and physical consequences of greenhouse gas emissions. Sadly, the short-sighted and economically driven policies of many states meant that little heed was paid, and today Vanuatu's people suffer from the insidious rise in sea levels that eats away at our villages, ocean acidification that is dissolving our reefs, increasing sea surface temperatures bleaching our corals and seagrasses, landslides that erase entire villages and plantations, and prolonged droughts that shrivel and kill our subsistence crops before they can even be harvested. This climate suffering is being experienced right now. Over the last 7 days, Vanuatu has been hit by 2 Category 4 cyclones, which leave us in a state of emergency today. All islands and 100% of our population is affected, with schools and clinics ripped from their foundations, infrastructure washed away, and food and water security severely compromised. This is unjust, as we are not responsible for the greenhouse gas emissions that are causing this crisis. Friends, this is not just a Vanuatu problem. What we are experiencing now, and have faced for many years, we see the rest of the world beginning to feel. We empathize with you and hope that we have the collective courage to turn this canoe around. 7 years ago, 196 countries adopted the Paris Agreement, the international treaty many hoped would finally take us off the path of planetary destruction. Countries around the world celebrated this landmark first step towards what we hoped would be accountable, transparent, and life-saving requirements to reduce the impact of global warming. But unfortunately, The pledges, promises and commitments made under this agreement take us well beyond the safe operating limit of 1.5 degrees. Little effort has been expended on the human rights related violations linked to climate change, and countries still tend to see the Paris Agreement as the only international law relevant to climate change. Beyond the UNFCCC, however, other instruments under agreed international law already contain clear obligations to prevent harm to the environment and protect human rights. Specifically, we see climate-relevant obligations in the Charter of the United Nations, the Universal Declaration of Human Rights, the International Covenants on Civil and Political Rights and on Economic, Social and Cultural Rights, the Conventions on the Rights of the Child, the United Nations Convention on the Law of the Sea, the Vienna Convention for the Protection of the Ozone Layer, the Montreal Protocol on Substances that Deplete the Ozone Layer, the Convention on Biological Diversity, the United Nations Convention to Combat Desertification, and more. But how can the obligations under a wide body of existing treaties be applied to the climate crisis? Pacific Island University students ask themselves and others these questions. Those discussions grew into a truly international call for clarity and for justice. Vanuatu accepted the call from our youth and has since been leading the campaign for an advisory opinion on climate change from the International Court of Justice. The United Nations International Court of Justice, or ICJ, is the only principal organ of the UN system that has not yet been given an opportunity to help address the climate crisis. To get to the court, Vanuatu and dozens of co-sponsoring states will table a resolution at the United Nations General Assembly. If the resolution is adopted, either by unanimous consensus or by a simple majority of votes, then the International Court of Justice will consider our question. You can read the full resolution on www.vanuatuicj.com. But in summary, we are asking two simple questions. What are the obligations that all states have under a range of international laws to protect the climate system and the environment from greenhouse gases? And two, what are the legal consequences when states actually do cause climate-related harm to other states or to future generations? It is our view that this question should have been asked long before now, and that the answer given by the world's highest court will help countries get back on track in upholding the rule of international law and bring human rights thinking into energy and climate decisions moving forward. I want to be very clear that this initiative is not intended to name or shame any particular nation. And despite being brought to the UN's highest legal body, we are not suing anybody. There will be no winners or losers, and no state will be required to do anything as a result of the advisory opinion of the court. Importantly, we are only asking for clarification of legal obligations already agreed under international law and not anything new. The question is also forward-looking, considering both historical emissions, but also emissions of today and the future. The primary goal of this exercise is to bring clarity to all states so that we can take better action moving forward. The resulting advisory opinion will help states revise and enhance their nationally determined contributions under the Paris Agreement and strengthen domestic laws and policies. The advisory opinion will likely identify gaps in international law, which will help us as we build and improve our multilateral climate negotiation processes. The advisory opinion will also ensure we base our relationships on the adherence to the rule of international law. As we have seen with the recent destabilizing war in Ukraine, we must prioritize an international legal framework that is clear on what is acceptable state behavior and what is not. The rule of law is foundational to the United Nations and to its mission of peace. From the smallest villages in the Pacific Islands to the global stage, the rule of law is all that stands between peace and stability and a climate-safe world and utter destruction. The rule of law protects the vulnerable and is the basis of international cooperation, especially in regards to climate change. Vanuatu has heard the strong call and expectation from grassroots youth movements and indeed over 1,700 civil society organizations from around the world to draft a forward-looking, indeed intergenerational question. Colleagues, the focus of the question is on the protection of fundamental human rights of present and future generations, a critical shift in narrative which may yield greater climate action and ambition among all states in the global community. I think we have been speaking about climate change in terms of degrees of Celsius and tons of carbon for too long. This is not relevant to many decision makers. It is time we reframe climate decision making in terms of human rights. So what is next? The UN General Assembly will hold a session on the climate justice resolution on the 29th of March this year. There are three options. One, the resolution will be adopted by consensus if all states agree. Two, the resolution will be adopted by simple majority vote if any state shamefully calls for a vote. Three, the resolution fails to be adopted, which is not expected. The early co-sponsoring nations were published on the 1st of March, and as of today, at least 113 other countries have confirmed they will support the adoption of this UNGA resolution. So we are nearly there. But I need your help to ensure that this resolution is adopted. Every country's support counts. There are still countries in the global north, and indeed in Latin America, Africa, and Asia, which have not yet confirmed their support. If you have networks or contacts with influence, now is the time to mobilize them before the adoption session in a few weeks' time. Excellencies, ladies and gentlemen, friends, it is time for the world's highest court to give us the clarity we all need to do more. We are out of time in Vanuatu, and our children need us to demonstrate the required leadership. Know that in Vanuatu, you have a staunch ally committed to fighting for climate justice. Thank you.
Well, many thanks to the Minister there for that very powerful testimony and analysis of the situation and explanation of the motivations for Vanuatu's action. I mean, I was particularly struck by saying that the focus on degrees, temperature, and tons of carbon has gone on for too long, and that there needs to be a reframing in terms of human rights, particularly in the context of current and future generations. I'm delighted to say we're also joined in this session by the Vanuatu ambassador to the UN, Otto Tevi. We're going to be hearing from him a little bit later during the Q&A session that follows. But let me turn straight away to our panelists, our expert panelists. Delighted to have Professor Lavanya Rajamani, Professor of Environmental Law at the University of Oxford. Among many achievements, Lavanya co-authored Human Rights and Climate Change, published in 2011. She was a coordinating lead author on the latest IPCC report and has been providing external legal advice to Vanuatu in this process. We also have Dr. Margareta Wewarinka Singh, Associate Professor of Sustainability Law at the University of Amsterdam and Counsel at Blue Ocean Law, and she's also a legal expert on all of these issues, in particular helping small island states. So we're going to hear from both of you. Perhaps Lavanya, you'd like to kick off and take us through your perspective on this initiative and what it means. So over to you.
Thank you, David. Very much along the lines of the remarks by the Minister, I'd like in my 5 to 7 minutes to make two context-setting points. First, that the UN climate change regime and the Paris Agreement is fundamentally limited and limiting in its ability to provide comprehensive problem-solving international climate governance. The Paris Agreement, the way it's been structured, functions as a catalyst to spur climate action within, between, and even beyond states. It uses procedural obligations in relation to submission of nationally determined contributions and transparency, and contains obligations of conduct, not obligations of result, in relation to mitigation. Crucially, it does not contain any mechanism to review the adequacy of an individual state's climate contribution. This was, of course, consciously negotiated by states and is not an oversight. Instead, the Paris Agreement relies on peer pressure to encourage and inspire action and to generate an upward spiral of ambition. Is this actually working? As the Minister noted, the current temperature trajectories are far above what is safe. So temperature trajectories are 1 degree lower than they would have been if the Paris Agreement had not existed. But based on existing policy, not promised targets, existing policy, we are on track to a 2.5 degree temperature rise. And at that level of temperature rise, there would be severe, pervasive, and irreversible impacts, and would mean the destruction of whole low-lying nations. which brings me to my second point. The Paris Agreement is not the last word on the responsibilities of states in relation to the climate harms that they unleash on others. It is only the last word on what states were able to negotiate through a consensus-based decision-making process. There is indeed, as the minister noted, a tapestry of interlocking international obligations and norms, including, but not limited to, the UN climate change regime. And a balanced assessment and interpretation of these norms, read in conjunction with each other, is necessary to paint a holistic picture of the rights and responsibilities of states in relation to climate harms. And the International Court of Justice can play a pivotal role in this area, and which is why the advisory opinion is extremely well-timed. For instance, the International Court of Justice could interpret the provisions of the Paris Agreement, in particular, the provisions relating to nationally determined contributions and the requirement for progression and highest possible ambition in these nationally determined contributions in light of the customary international law principle of harm prevention and the duty of due diligence that attaches to it. While states may not have obligations of result attached to their nationally determined contributions, they do have obligations of conduct in relation to the domestic mitigation measures that they're required to take to implement their nationally determined contributions. The duty of due diligence attaches to these obligations of conduct, due diligence, which means that states have an obligation to deploy adequate means, to exercise best possible efforts, and to do the utmost to obtain particular results. If the International Court of Justice fleshes out, and this is just one example of something the ICJ could do, if it fleshes out and concretizes the standard of due diligence in this context, it would constrain the discretion and autonomy that states have in choosing and implementing their nationally determined contributions, which, as we all know, are far below the ambition required to actually meet a 1.5-degree temperature target. So limiting the discretion and autonomy that states have in choosing and implementing their nationally determined contributions based on standards of due diligence, much needed. Ultimately, the International Court of Justice could, by interpreting the relatively open-textured treaty obligations in the Paris Agreement in the light of well-established customary international law principles, as well as principles of international environmental law, bring much-needed clarity to the nature and extent of legal obligations that states have in relation to addressing climate change. Thank you.
Well, thank you very much indeed for that. That's a fascinating summary of the situation as regards the law in relation to the Paris Agreement. And Lavanya, we'll come back to you during the Q&A, I'm sure, to amplify some of those points. Margareta, should we turn to you next to hear your perspective? As I say, 5, 7, 8 minutes is yours.
Thank you very much, David. Well, my remarks are also very much complementary to what Minister Regenvanu and Lavanya have already said. And I am inspired by the title of this event to zoom in a little bit onto the human rights dimension of this initiative. So many of you know that over the past 15 years or so, much has happened in terms of increasing recognition of the relationship between climate change and human rights. And this started really, at least at the international level, with the Inuit petition that was filed by indigenous members of the Inuit community in the Arctic, who petitioned the Inter-American Commission of Human Rights, alleging that their rights under the American Declaration on the Rights and Duties of Man had been violated as a result of the state's failure to take adequate action on climate change. It was a very well documented petition with much evidence about the impacts of climate change on a range of their rights, including the right to culture and the right to self-determination. Now, this petition was not formally acted upon by the Commission. The Commission sent a letter to the petitioners that it was, based on the information that had been provided, unable to establish whether their rights had been violated, but it did trigger a conversation with the petitioners and also with other communities from across Latin America about the ways in which climate change affected human rights. It also inspired states from a very different part of the world, small island states, who came together in Mali in 2007 for the Mali Conference on climate change and the human impacts of on the human impacts of climate change, which in turn inspired leaders from SIDS to bring climate change to the Human Rights Council. That resulted in the first resolution that the Human Rights Council adopted on climate change and human rights. And what is important to realize at this point in time is that back then it was far from obvious that climate change was a human rights issue, or that the Human Rights Council should really have this on the agenda. It was a contentious move at the time, but the small island states had actually a very, I think, wise diplomatic strategy. So instead of pushing it too hard, the first resolution on climate change and human rights introduced the issue gently, not even highlighting specific rights just yet, but asking the Office of the High Commissioner for Human Rights for a study to explain to the member states how climate change affects the enjoyment of human rights and what exactly is the relationship between climate change and human rights. That study was delivered, and then the next resolution was adopted. Fast forward to February this year, we have 12 resolutions from the Human Rights Council on climate change and human rights, which articulate with an increasing level of clarity how climate change affects the enjoyment of human rights, and also has called for many different panel discussions, reports, and other forms of action to further unpack the various ways in which climate change affects human rights. Also, of course, as we know, the Human Rights Council has recently established a mandate for a special rapporteur on climate change and human rights, which civil society had already called for in 2010. It sometimes takes some time for a body like the Human Rights Council to act upon such a call, but it has happened in the end. And so even more is now happening in terms of understanding these relationships and also understanding how climate change affects the enjoyment of human rights on the ground. Of course, in parallel, within the climate change regime, work has also been done to draw connections between climate change and human rights. So it was in 2010 in Cancun, in the Cancun agreements, that states for the first time in a COP decision highlighted obligations of states to respect human rights in all climate change related actions. And in the Paris Agreement, of course, there's a preamble paragraph referencing human rights. Now, an ICJ advisory opinion can build on these normative developments by providing clear and authoritative statements about the legal obligations of states precisely on this intersection between climate change and human rights. And as Lavanya highlighted, really confirm and consolidate what is a tapestry of obligations of which human rights are a very important part. And so this is about obligations to prevent future harm, to protect vulnerable populations, to ensure that climate policies and actions themselves respect and promote human rights, including rights to participation. And also it is very much about ensuring that when rights are violated, there are remedies for victims. And so human rights have been at the center of this campaign as a result of the youth advocacy, which is from the very beginning emphasize the need to focus on the rights of present and future generations. And so they are part of the legal question that has been articulated in the resolution. So it's very much expected that the court will take this dimension seriously. Now, what can various actors do to spur and consolidate progress in this field by participating in the initiative? Of course, the proceedings that we expect will start in the course of this year before the court in The Hague are very inclusive. All states, our UN member states, are entitled to make submissions. And so there is an opportunity for all states to provide evidence. Evidence will be as important as legal arguments. It will be very important to show the court and the world how human rights are actually affected by the impact of climate change all around the world, to really draw out this evidence and also tell the story about the impact, the human rights impact that are already being suffered, as well as a story about protections and how human rights can be protected in climate through sufficiently ambitious climate action, but also action that is itself aligned with human rights. And then, of course, to make the legal arguments that are aligned with this evidence about the need to act with due diligence, as Lavanya said, in order to protect those rights. And for the scholarly community, there is an important opportunity to provide analysis, legal arguments that all feed into the discourse that shapes this initiative. So in sum, there are many ways to contribute to this discourse, or I think we can say a movement that has been formed around this initiative. And of course, different actors have different roles to play, but it is an initiative that is extremely ambitious, and it will only succeed if there is widespread, full participation from around the world, from state actors, from NGOs, from the legal community, etc. All hands on deck to make sure that the story is told in full, all of the relevant evidence and arguments are presented, and that will then enable the courts to deliver the opinion.
Thank you very much, Margareta. That's great to hear your analysis of where we are. And I particularly like the phrase, the tapestry of obligations that already exists on human rights. And I guess the ICJ advisory opinion, when we get there, will really help consolidate all of that. So fascinating to hear that. Questions have started to come in. For those of you who don't know how it works, at the bottom of your screen on Zoom, there's the Q&A function. Just type in your question, and I see 3 have come in already. We'll try to get to as many as we can. But I wonder if I can just use my moderator's privilege to ask a question of Ambassador Odo Tevi in New York. Ambassador, thank you for getting up so early to join this session, but it's really invaluable to have your contribution. I wonder whether you could just, having heard the legal experts, the situation as they see it, just your assessment from where you are at the UN in New York about the numbers supporting your hope for a resolution, how you see the diplomatic land lying on this initiative of yours.
Well, thank you. Well, at the beginning, it was not easy when we took this resolution. But what happened was that during the demands that we were negotiating and talking to other states, we were able to form a group called a co-group, which is the Friends of the Initiative. And that co-group was pivotal, and it consists of countries around the world representing major regions of the world. And I think they were the ones who were able to talk to other countries and try to ask them to co-sponsor the resolution. And of course, the diplomatic efforts made by the capital, made by the government of Vanuatu, as well as other governments in the Pacific region. As it stands, we have over 100 co-sponsors. So on the L document, which is listed on the resolution, so you will find that there are 105 co-sponsors. So we need a majority of 97 countries. So if you include those who are voting and present, the 193 members of the United Nations, so you would need 97 countries to vote in favor to form a simple majority. So we have exceeded that already. That's reflected on the resolution. And in terms of the additional co-sponsors, we have another around 10. So it should be around 113, 14, 15 by now, but the numbers keep on changing. So we have the majority, the required number already to vote. But of course, as you know, there could be last minute changes or political negotiations on the sides. But so far we are comfortable that if we take it to the General Assembly, and the date for the adoption will be around 29 March. That's Wednesday this month. And we are confident that the resolution will be adopted. And what I have found throughout this process is that there is a lot of goodwill. So it also unified the developed and the developing countries, even though they have a different perspective on the resolution. But what's important is to what we did here at the UN is to find a balanced text that can satisfy the developed and the developing countries. So as a result of that, you can see there is an overwhelming support. And there are some countries which are still not on board in terms of co-sponsorship, but I believe they will vote for the resolution at the end. Currently the climate here at the UN, it's excellent, and a lot of countries are looking forward to the adoption of the resolution.
That's very interesting. And just before the panel started, we were hearing how the European Union countries have come on board. I mean, interestingly, one might, as an outsider to this process, have assumed that it would be the global South, that nations that would typically be in support. But having the European Union support you, that must have been an important moment.
Yeah, that's an important moment. I mean, when we started this resolution, our fear is that the major emitters might not support it, but also the developed countries, but also the developing countries. Some of the developing countries may not support it. But what we did was we formed a core group, and the core group was the microcosm of the UN. So we had developed countries in there, like Germany, like Romania. They were able to contribute to the resolution. So the approach was more inclusive and participatory, but also it touches a number of issues, like Lavanya and Margareta was highlighting on human rights, present and future generation. So it's not only about Vanuatu, but it's about the present and future generation. So it's not only relating to Vanuatu, but the globe. And there is also the youth movement around the world that they're talking to their governments and they're advocating and trying to influence them to support the resolution. So I would say it's a global public good if we have a favorable advisory opinion, because it will help humanity. It's not only about the people in Vanuatu or in the Pacific, but it helps whether you are in Africa, whether you're in Latin America or in Europe, it will help. But also the global environment also help. For example, the tensions in Ukraine and Russia. We've been talking about international law, upholding international law, the existential threat. And so for the small island states like Vanuatu or the atoll states in the Pacific, climate change poses an existential threat. So we also need international law on our side to protect our country, our sovereignty, and our people. I think that's very important. So for small states like Vanuatu, we don't have nuclear weapons, we don't have a huge army, but we rely on international law.
So yeah, thank you for that. It's a very compelling argument, Ambassador. So thank you for that. Look, picking up on a question we've had in the Q&A, and do keep sending them in, from Roberto, who's not from a law background, and nor am I. So it's a question that really resonates with me. And I wonder if I could throw it to you, Lavanya. It's, what is the, if you get, let's say all goes well at the UN, and I've reported on enough UN initiatives known not to try to predict the outcome of that, but fingers crossed for all of that. But let's say you then get to the International Court of Justice and the advisory opinion does come out. What that actually means in climate mitigation terms, what does it mean in terms of pragmatic climate action? Lavanya, I wonder whether you would talk us through, because I mean, as I understand it, the advisory opinion is advisory, it's not legally binding on any state. So how does it translate into reducing emissions, into climate action?
Thank you, David. That's a great question. I think, as you said, it's an advisory opinion. It's not binding, but the advisory opinions of the International Court of Justice, the world's highest court, have tremendous legal gravitas, and they will have ripple effects across the negotiations, the climate change negotiations, as well as national decision-making. And national decision-making, not just on policies in relation to climate change and actions in relation to climate change, but also in terms of actually drafting nationally determined contributions, as the minister mentioned as well. The hope is that the extent to which the ICJ will speak to the importance, the due diligence, the high standard of due diligence attached to climate action will translate at the domestic level into hopefully more ambitious nationally determined contributions as nations revise nationally determined contributions on a periodic basis. I think a strong statement and a clarification of legal obligations from the ICJ will also have an impact on national courts, decisions of national courts. There are many cases in national courts and regional courts. The European Court of Human Rights, for instance, has 3 cases that are currently before the Grand Chamber on climate change. And strong statement and clarification of legal rights and obligations of states from the International Court of Justice will have an impact on national courts and regional courts as well, in relation to how the pendulum is swinging in terms of ensuring legal rights and obligations of states are actually being implemented. So I think it has tremendous ripple effects. It's not in the effects of the ICJ advisory opinion are not in terms of coercing states to do anything. That's not, as the minister mentioned as well, that's not the intent. It's to influence the negotiations, influence national decision-making, influence national court decisions, as well as regional court decisions. Thank you.
That's really clear. Thank you very much indeed. And let's just follow that up with a question from Alex, really about, I guess it comes down to strategy and whether pursuing the human rights avenue as you're doing, and this is really a question for Margareta, I guess, is likely to prove more effective than arguments based on intergenerational equity. I mean, which one, Margareta, do you reckon is likely to prove more effective? I mean, clearly you're going to argue that it's human rights, but how that cuts through internationally?
Well, I would answer by first saying that I think that intergenerational equity and human rights are very much two sides of the same coin. I wouldn't see them as competing framings, but very much as compatible framings that are ultimately that really need each other and depend on each other. Of course, when it comes to, for example, the rights of future generations, that is an area where the law arguably still needs further developments. The rights of future generations have not been very clearly recognized in international jurisprudence. And I'm saying not clearly, it's not to say not at all. There are some pointers, but it is an area that's certainly there is space for gap filling. When it comes to human rights more generally, of course, obligations are very well established. There is a very rich body of jurisprudence from all around the globe, from domestic courts, from regional courts, from international courts, and there is just very much to build upon. And for lawyers, a kind of logical source to turn to when you want to understand what obligations mean is jurisprudence. And of course, the UNFCCC and the Paris Agreement have not really benefited from judicial clarification much, because there is no judicial body that really has overseen compliance, let's say, with these treaties. And domestic courts increasingly start to engage with these treaties, but still there's minimal authoritative pronouncement on them. So, and the same goes for future generations, intergenerational equity, although there is some. So again, yeah, these are different parts. I think one narrative, the youth movement that has really spearheaded this campaign has, from the beginning, made it clear that for them, the rights of present and future generations are at stake and deserve attention from states and from the courts. So it will be very interesting to see what submissions states will be making along these lines, and what the court will ultimately say about the intersection between these obligations and principles.
That's going to be fascinating to see, isn't it? And also just as we were discussing earlier, how there's the range of countries supporting this initiative at the UN. It's not just something Global South, that other developed nations have come on board as well. We heard earlier from Ambassador Tevi in New York about how things are going at the UN in there, but obviously critical also to the effort to galvanizing support from other regions and countries. It's the work of Vanuatu's ambassador in Brussels, and I'm delighted to say that George Maniori is also part of this session. Ambassador Maniori, would you like to share your perspective on getting support from Europe, the European nations, and other parts of the world to get behind this initiative, and kind of what that means for your hopes, really, for what this initiative can achieve ultimately?
Yes, thank you very much, David, and good morning or evening to other colleagues listening. Yes, I believe that the action that is, well, we have in Europe, and basically our role is to assist Ambassador Odo in sharing the familiarizing missions and embassies in Europe. Not only in Europe, but as you may be aware, we have the this organization of the African, Caribbean, and Pacific states that is based in Brussels, and that is where we have reached out to successively get the process of decision making within that organization to adopt or approve the initiative that Vanuatu has been leading. we have managed to obtain say support from the organization through a leaders summit declaration that was held in Angola December last year, and also we managed to obtain some resolution from the Joint Parliamentary Assembly from the European Union and the African, Caribbean, and ACP Group of States to approve and call for support for the initiative. I believe that these actions have also managed to get the ears and of the leaders of the EU, but also to mention that our Minister of Foreign Affairs has also led a number of missions in Europe to have bilaterals with leaders in Europe, specifically to provide them with the rationale behind the initiative, and to explain that this is not something that Vanuatu with the Global South leading against European. But as we know, European leaders, including UK, have been champions in climate change initiatives and have come up with a lot of initiatives to address climate change. So the minister, I believe, this face-to-face dialogue has proved to be very useful, in that the minister has managed to give European leaders the rationale why Vanuatu has been leading this initiative, and it is an initiative that will help not only the South but also the countries from the North to also have to grasp to have a better understanding and of what international legal framework provides for climate change. So I believe that it has been very an exciting diplomatic work, but I believe that it has proved to be very useful in terms of getting support.
Ambassador, many thanks for those remarks. Fascinating to hear your work in this area. Let's just switch to some of the questions that have been coming in, and very grateful to everybody who has sent a question in. Khaled El Mahmoud asks quite a technical question here, considering the advisory proceedings instituted before the ITLOS by COSIS and the IACTHR. I'm going to confess I don't know what all these are, but by Chile and Colombia. The question arises as to whether this development will lead to a fragmentation of climate change law. Lavanya, do you want to, you'll be across, I'm sure, all these acronyms. There's a great plethora of different initiatives legally. And what Khaled seems to be asking about is whether this will lead to a fragmentation or whether they can somehow coordinate.
So while the courts, the question is about the different sort of advisory proceedings that have been instituted in different courts, the Tribunal for the Law of the Sea, the Inter-American Court on Human Rights, and of course the ICJ. The question about fragmentation is an interesting one, but there will be no actual coordination between the work of these courts, obviously, and they will reach their conclusions independently of each other. But what I'd like to point out is that the ICJ is the only court of general jurisdiction. It is not limited in the treaties that it can consider. It's not limited in the obligations, the customary international law obligations that it can consider, whereas every other forum is broadly limited either in a regional sense or to the treaty that has set it up. Not so the International Court of Justice. The International Court of Justice, as I said, only court of general jurisdiction. So any advisory opinion that emerges from the International Court of Justice on this will have tremendous legal gravitas and will be far more progressive in the sense of covering, well, comprehensive rather, in terms of covering all of the interlocking tapestry of obligations, or at least should be tapestry of obligations, and to provide clarity on the legal rights and obligations of states. The other tribunals will in some senses, may be more progressive. The Inter-American Court has has a reputation of being a very progressive court. It might come up with a very progressive sort of judgment, but it will be limited in its reach and will be limited also in relation to the treaties that it actually covers. So there will not be fragmentation as such, and there will not be coordination between the courts, but they will stand and complement each other. Thank you.
And an interesting question, thank you for that, and to Khaled for posing it, from Adela Pavkova, who says that when she contacted her country's UN mission about this campaign, the appointed lawyer disagreed that the advisory opinion would increase the enforceability of climate commitments made under international agreements, I guess Paris and so forth, but was reluctant to elaborate. Margareta, do you want to pick that up? I mean, is there a counter argument here that whatever opinion eventually lands from the ICJ, we've heard already from Lavanya saying it's non-binding, obviously, but actually it won't make a lot of difference in terms of enforcing climate commitments?
Yes, this is a good question, and I think for us this is an issue that we have analyzed as part of our risk analysis on the initiative. What are the various negative outcomes or disappointing outcomes that could be generated? And this is probably the highest risk, because other risks, such as the court declining to provide an opinion in the first place, saying that it doesn't have jurisdiction, we think is a very, very small risk, given that the UNGA can ask for advice on any legal question. The chances of the ICJ providing an opinion that is tremendously unhelpful, for example, so there are no obligations whatsoever, it also seems to be very small. So this is the real risk, that the ICJ will come up with an opinion that is perhaps, that looks nice, that may say some nice looking things, but it doesn't have a real impact in practice and doesn't help to really create greater clarity about obligations or legal consequences. So why are we optimistic about the court providing an opinion that is going to be helpful and that will lead, we think, primarily to greater compliance with obligations? Because we're also optimistic about what will happen once the opinion is delivered. Here, I think it's important to remember, all of us, about that how international law really works. Right? It's not a police force or a big enforcement institution, but still, I think we international lawyers, we like to quote Louis Henken, who said, almost all nations comply almost with almost all principles and almost all of their obligations under international law almost all of the time. So, of course, there are exceptions, and the exceptions get a lot of attention, but the compliance that happens most of the time is largely unnoted, but it is a fact. And so, but that compliance and requires also that states know what their obligations are. So we are optimistic about the court providing that clarity, the clarity about the scope and content of the obligations, say what states exactly need to do, and also the clarity that there are legal consequences when harm is caused and when these obligations are not complied with. And that is one, because of the way the question is formulated. And of course, as the legal team, we have paid very specific attention to that. And this has been a participatory process where members, and including legal experts from the core group, the members of the core group have all together worked on the question and made sure that it's formulated in a way that really invites the court to provide this clarity in a helpful way. And also, it will be very important that states will be participating in the legal proceedings and will also invite the courts very explicitly to provide this clarity on specific points that states can raise. And so this whole process should lead to an opinion that is specific, and thus leads to hopefully most of all greater compliance, and then if compliance is not there, greater enforceability.
Margareta, thank you very much for that. Now we're really into the last couple of minutes, really, this. I just want to come back to Lavanya with a question from Lena Cohn, who says that if there is this advisory opinion from the ICJ concerning state obligations, is there a risk of driving states to withdraw their support for the ICJ out of fear of being held responsible? This is a meaty question right at the end, and if you can give a brief answer, that would be appreciated.
Yeah, so just a brief response. This is an advisory opinion, and the strategy, as the minister pointed out right in the beginning, strategy of the Vanuatu team to sort of go for an advisory opinion rather than a contentious case, against one of the major emitters, was precisely this, so that it would not alienate particular countries, would not sort of engage in the blame game. It was not about finding winners and losers. It was about finding clarity in legal obligations. So it is not, I don't think it's a serious risk that states will sort of withdraw their consent to the jurisdiction of the court as a result of an advisory opinion on an issue, an existential threat that's facing the world. I think the advisory opinion strategy was very carefully thought out precisely to sort of sidestep any such risk of states sort of withdrawing their consent from the court or from feeling targeted in any way. Thank you.
Right. So your hope is to create a kind of consensus about this, and so that nobody feels alienated or victimized. Look, we've run out of time. Thank you all very much for those of you who posed questions. Sorry we didn't get to all of them. I think we got to a good number of them, and fascinating they all were. Let me just highlight for those interested, for the latest running total of countries in support of this initiative, please go to the website www.vanuatuicj.com. I'm told the big day set in the UN calendar is March the 29th for this to be debated. Fingers crossed that all goes well for delegates from Vanuatu and everyone in support of them. Big thank you to our panelists, to everyone who's taken part, and to the organizers. And I wish you all a very good day. Thank you very much indeed.